So, welcome to the second episode in our podcast series on business and corporate law fundamentals, where we take you to the courtroom and look at the various judgments from the courtrooms and various regulatory actions that have been taken on businesses and the consequences of decisions that the CEOs, board of directors, and the company itself engage in, resulting into the piercing of the corporate veil, as well as the importance of corporate governance and how the non-compliance with laws, regulations, as well as best practices in corporate governance can result to significant corporate failure and impact the success of an organization. The purpose of this series is to, among other things, bring you from the classroom as you are learning for your ICAG, ACCA, CIMA examination, the various things that you are learning on ethics, corporate governance, business management, and various issues, how they are applying in the corporate world, and why it is important that the things that you are learning are implemented the way they are supposed to be implemented to ensure that we have successful companies. In addition to that, the series is also to provide blueprints to rising entrepreneurs to understand the importance of adhering to best practices and norms to enable them to build successful companies so that they will not build companies to a point where they would then have to be held accountable or responsible because of a decision that they make that they were not supposed to make. And these are some of the things that we want to share our thoughts on in this series. On today's episode, we are looking at Zeepay. You have heard the news and you've seen the various issues, including the regulatory actions that the Bank of Ghana has taken for the revocation of their license, and we'll get into all of that in the series. And we are looking at Zeepay today and why the CEO was held accountable for the decisions that he made or he was involved in making in the running of the organization. Now, this is a court case between the plaintiff, who is Michael Yusuf, who is a plaintiff and then the merchant, versus Zeepay Ghana Limited, a fintech firm, and Andrew Techi Appiah, CEO, who is the second defendant. Now, you want to ask yourself, why did the plaintiff bring a case against the company and the CEO? Because why? Remember, we spoke about the Moko and Kuma issue, right? The Supreme Court's ruling in the 1999-2000 that sets the precedence of the importance of separation of corporate personality and personal liability. In that case, also, Kuma brought the CEO and the company to court because the company was not able to pay for something that they have delivered or supplied to them. But the Supreme Court ruled that, hey, listen, the CEO only signed a contract on behalf of the company, so the CEO cannot be held accountable for the non-payment of the debt. And so any issue that is involving companies and the CEO also is coming in is not surprising. But the question we need to then ask ourselves is, will the CEO be held accountable? Will the corporate veil be pierced? Let's look at this case. So Michael Yusuf versus Zeepay Ghana Limited and Andrew Techi Mensah. What was the claim? Simple. Unfulfilled international SWIFT transfer totaling 11.9 million US dollars and 8,500 euros. So that was the claim. This case took place at the High Court of Justice, Commercial Division, Accra, and the presiding judge was Her Ladyship, Justice Afi Agbanu Kumodo. Date was on the 16th of April, 2026. The verdict was simple. Summary judgment granted for the plaintiff, severe financial penalties, executive assets seized. So that was the judgment. Now, what was the operational model? Because the whole claim of Michael was that, hey, listen, I gave you money, that you should send this money to my clients, because I took this money from my clients and brought it to you people and say, hey, send it to these people. You have acknowledged the receipt of the money, but you didn't send the money to the people. So this was the claim. Let's look at the intended operating model for Zeepay. Client instruction. Yusuf received instruction from global clients to facilitate international funds transfers. Number two, the WhatsApp rate negotiation. informal treasury management. Now, this is an informal treasury management because deals of this nature should not be discussed on WhatsApp. Like there should be a proper treasury management system where exchange rates and issues are negotiated. And I'm going to come back to why that is important, because one of the defense of Zeepay and the CEO was that the rates that he is claiming to be paid was not agreed on by the Treasury Committee of Zeepay. But Yusuf provided evidence in court on the WhatsApp interaction and various things about the agreements of the rate. So that's where the problem was. The exchange rates are negotiated in a dedicated WhatsApp group containing Michael, Zeepay's treasurer, the assistant treasurer, and the CEO. So the CEO himself was part of the negotiation of the exchange rate. So once the rate was agreed, he received instruction. He then contacted Zeepay and agreed the exchange rate in a dedicated WhatsApp group. Zeepay treasurers and the assistant and the CEO all agreed the exchange rate. And then Yusuf transfers the Ghana cedi equivalent to Zeepay corporate accounts. The Ghana cedi equivalent to Zeepay's corporate account. So whatever it is, we agree the exchange rate. Yusuf transferred the Ghana cedi equivalent. Then we go to the fourth step, the SWIFT generation. Zeepay generates official SWIFT advice confirming transfer amount, fees, beneficiary details, and strict business execution of the transfer. So that is the intended operating model of the entity. You want to send money? Okay. We set up a WhatsApp group. We agree the rate. Okay. You send us the money. We acknowledge the receipt of the money. The agreement is between 2 days. We will execute and transfer the money to your clients. Okay. But this is where the control failure comes in. Because you see, there was a fatal flaw, the systemic commingling. That is the amalgamation or blending of funds. Client funds were systematically directed into the personal Momo wallet of CEO Andrew Techi Appiah instead of a dedicated corporate escrow or operational account. So whilst clients were bringing the money was being transferred into the personal wallet of the CEO. Now, you got to be careful about this, because this is where Bank of Ghana comes in. Because the Bank of Ghana has revoked the dedicated electronic money issuer, that is DEMI, license of Zeepay Ghana. What was the reason for the revocation of the license? The central bank cited multiple regulatory breaches, including issuing electronic money without maintaining the required cash backing, creating a negative balance variance, failing to inject required funds to cover e-money balances, and ignoring directives to wind down its electronic money issuance operations. What was the legal basis for this? The action was taken under Section 13 of the Payment System and Services Act 2019, Act 987, to safeguard the stability of the national payment system and protect consumers. So, Bank of Ghana revoked their license. Why? Because per transaction records, it is showing that, it is showing that Zeepay has received 10,000. Okay, if we take out their fees and everything from it, they are supposed to then transfer 8,000 to customers. But if we look at the account of Zeepay, Zeepay is having negative 10,000. So they are not having enough money in their account to service how much of the e-money that they have issued. This is the systemic issue. So the question we then have to ask ourselves is, as the customers were bringing the money, where were they keeping the money? Because the purpose of the dedicated electronic money issuer license is you have to keep the same money that you have collected. we subtract your fees from it. And so if people have brought in 11 million, okay, how much was your fees? Your fees was, let's say, 100,000. Then you're supposed to have 10.9 million sitting in an account. But here we are consistently, you are having a negative balance. Then Bank of Ghana says, hey, listen, we cannot allow this to be going on. So what do? We revoke your license. And so the explanation that can be given as per this case was the evidence that Michael Youssef provided in court, indicating that systematically client funds were directed into the personal mobile money wallet of the CEO. And so what it means then is that there was no separation between the company's money and the CEO's money. Under no circumstance should the CEO be the one receiving business money. You shouldn't be doing that, because immediately you do that, then that is where commingling, amalgamation, blending comes in. It then means that there is no longer a separation between the company and the CEO. So if the CEO can receive company's money and then in his personal account and will transfer from the personal account back to the company's account later on, then the CEO is the company is the CEO. And so the two have become one. In that case, if there is any legal obligation, then the corporate veil must be pierced. This is what is happening here. Now, let me say this, that this case is still in court because they are appealing the judgment. Nonetheless, their licenses have been revoked by the Bank of Ghana, but they are appealing the judgment of this particular case. And so the question is, what went wrong? From April to September 2025, transactions proceeded smoothly. In other words, okay, whatever money Youssef brought, Zeepay was able to execute the deal, execute the transfer. There was no problem. But starting in September, October 2025, transfers suffered unexplained delay, leaving recipient payment unfulfilled. What was the deficit? Uncompleted transaction totaled $11.9 million and 8,500 euros. Following a meeting where Zeepay acknowledged non-transfer of funds and financial distress, Zeepay made partial repayment and transfers of 340,000 US dollars and 1 million Ghana cedi, leaving substantial balances outstanding. Okay, this was what went wrong. But you then have to ask yourself, how is the company having financial challenges? How is the company in financial distress? How? To the tune that over $11.9 million payment was not possible. Where did the money go? And they were able to pay only 340,000 US dollars. Where did the money go? But what was the defense of Zeepay and then the CEO, because he was part of the case? Zeepay and Andrew Techi filed an affidavit in opposition seeking to throw out the summary judgment application, arguing, 1, lack of capacity and locus standi. They asserted that Youssef lacked legal standing or capacity to initiate the lawsuit. Interesting, right? So they are saying that, hey, Michael Youssef, you are a merchant. You brought us the money, but Michael doesn't have the legal capacity to bring a case in the first place. 2, improper party, that is disjoiner of CEO. They argue that the second defendant, the CEO, was improperly joined as a party and should not share the personal liability with the company. So that was the argument again. But remember what Youssef has said. Youssef had provided evidence that, hey, listen, there are records indicating that monies end up in the accounts, in the personal Momo account of the CEO. Right? And but in addition to that, now we are learning that Bank of Ghana has revoked their license because of the negative balance variance that they were having. So who is supposed to be held accountable? The CEO has to be, because if he was involved in negotiating the deal and there are evidence that some money ended up in his account, then he should be held accountable. 3, Unapproved exchange rate. They claimed the exchange rate used in generating the SWIFT advice had not been approved by Zeepay's management committee. Okay. So if the exchange rate was not approved, why did you issue the SWIFT advice in the first place? So you are looking at the internal control failures here. You are looking at the poor corporate governance issues here. You are looking at the fact that decisions are being made by just a handful of people who are now saying that, yes, the rate that we agreed on WhatsApp was not approved by management committee. If it wasn't approved, how did you issue the SWIFT advice? Because the SWIFT advice refers to the official standardized electronic message sent over the SWIFT network to notify a party that a payment or fund transfer has been processed. How do you process a transfer when the exchange rate had not been approved by your own management committee as you are defending? So, poor corporate governance. Maybe there is lack or inadequacy of internal controls. Or if the controls are there, they are not effective, they are not efficient. And the decisions are being made by a handful of people: treasurer, assistant treasurer, and the CEO. So these are the three people who made the decision about what the exchange rate should be and what should be done generally. A typical system of poor corporate governance of a company in a highly regulated environment like that. Then the fourth thing, allegation of fraud. They allege that Yusuf activities were fraudulent and criminal, creating triable issues of facts that required full trial. Because this case was really swift, okay? So they are like, hey, some of the things that Michael was doing are illegal, so we need to go to full trial, bring in witnesses, come and defend things and all that and all that. So these were the arguments. So let's come then to the corporate veil. Why was the CEO supposed to be part of this case? Because remember, in their defense, they said, hey, the CEO should not be liable to the liabilities of the company. But why was the corporate veil pierced? Why? So the shattered shield, personal liability exposed. Liability protects the executive from personal ruin unless they abandon corporate formalities. By commingling multi-million-dollar client fund directly into his personal mobile money wallet, the CEO effectively erased the boundary between himself and the corporation. The legal shield shattered, exposing him to direct personal liability for corporate debts. So really what is happening here is that because you are receiving the money in your account, it means that that boundary has been shattered. We cannot say, yeah, the company is a different person from the CEO. No, the CEO has allowed his own private funds to be used to receive money on behalf of the company. And so what was the summary ruling? What was the ruling generally? Okay. Order 14 summary judgment. So what was the ruling? So the argument, capacity. Zeepay's legal stand. Yusuf lack locus standi. That is the legal capacity to initiate the lawsuit. The court's ruling. Validated. Defendants legally admitted Yusuf's capacity by choosing to file a counterclaim against him. So that is it. If you can sue somebody, then the person also has the capacity to sue you. 2, liability. Disjoiner request. Zeepay's legal stand, the disjoiner request. The CEO cannot be held personally liable. Zeepay is a separate limited liability entity. The court's ruling. CEO remains liable. Request for disjoiner rejected. The personal Momo wallet transfers validate him as a proper party to the suit. 3, authorization. The exchange rate used in the SWIFT advice were never formally approved by the internal management committee. So this is Zeepay's legal stance. What was the ruling? Binding actions. Under Section 147 of the Companies Act 2019, Act 992, actions taken by officers in official capacity bind the corporation. SWIFT advices are legally valid because we have negotiated a deal on WhatsApp. You have issued a swift advice, acknowledge that the funds has been what? Transferred. Fraud. Vague allegations that users' financial activities were fraudulent, demanding a full trial rather than a summary judgment. The court's ruling. Dismissal. Summary judgments cannot be barred by vague, unparticularized fraud allegation lacking concrete evidence. In other words, what you are alleging that Michael Youssef action is fraudulent, is criminal, there was no evidence to prove that. And so what was the financial judgment? Simple. The High Court ordered Zeepay and CEO to pay jointly and severally $11,585,753 US dollars, 8,500 euros, 1,400,000 Ghana cedis. Secondary penalties plus continuous interest accrued from judgment date until the final payment, plus 500,000 Ghana cedis awarded in legal costs to the plaintiff. Come on, this is serious, man. Right? This is serious. So 500,000 Ghana cedis awarded in legal costs to the plaintiff. So literally, I came to court because you couldn't do your job well. And because of that, now you'll be responsible for paying my legal debt as well in addition to that. So that was the case. Then the procedural mechanic, appeal versus execution. Filing an appeal to a high court is a slow process that does not automatically freeze judgment under the Ghanaian civil law. Unless the appellate court issues an explicit formal stay of execution, the winner of the suit becomes a judgment creditor who can legally collect immediately regardless of the pending appeal. Because they have already started taking actions. There has been videos of seizing the CEO's properties, his house and things already. But the lawyers of the CEO and Zeepay are saying that, hey, listen, we have appealed the case. But the fact that you have appealed the case does not mean the judgment will not go on. It is only when you specifically secure a stay of execution of the judgment, then nothing can be done. Because stay of execution simply means, hey, yes, although judgment has been given and you are entitled to all this money, you cannot execute or collect this money for now because there is a case ongoing. But currently, there is no stay of execution as at the time of recording this video. And for that reason, certainly it means that the money will be collected. So what has been the aftermath of this? Late of June 2026, Zeepay filed a formal appeal with the Court of Appeal challenging the High Court judgment. As of July 2026, because no stay of execution was granted, court bailiffs, accompanied by police officers, execute enforcement procedures. They seize a private residential property belonging to CEO Andrew Techi Appiah to satisfy the joint and several judgment debts. And these are the things that we must understand in the case of Zeepay, in the case of Michael Youssef versus Zeepay and Andrew Techi Appiah. Now, what are the key takeaways here? The key takeaways here are, number one, a client had paid money to Zeepay to be transferred to their client. The treasurer and the assistant treasurer and the CEO and Youssef on a WhatsApp page agreed on the exchange rate applicable. 3, the plaintiff, Michael, then sent the money to Zeepay to be sent to its client. Zeepay issued a swift advice, literally an acknowledgement of the process. However, Zeepay said the exchange rate agreed on was not approved by their management committee, indicating that there is lack of good corporate governance of a company in a highly regulated environment like that. There is lack of internal controls, or if there are internal controls, the internal controls are inefficient or effective. But here is the play, because I want to share something with you here carefully. When negotiating or agreeing on foreign exchange rate for institutional, banking, or remittance transactions, Financial institutions and regulated entities are expected to avoid informal messaging channels like WhatsApp and instead use authorized, regulated, and auditable platforms. Under Bank of Ghana foreign exchange rules and global financial standards, exchange rates and trades should be negotiated, executed, or confirmed on the following official platforms. 1. Professional FX trading terminals. 2. And this can be either a Bloomberg terminal or can be the Refinitiv FX matching or dealing. 2. Institutional settlement and confirmation networks like the SWIFT MT300 or ISO 20022. 3. Regulatory and central bank platforms like the BOG Centralized FX Trading Platform or the ORAS, that is the Online Regulatory Analytic and Surveillance System. Or 4. Enterprise Treasury and Bank API System, Bank Grade Treasury Management System, TMS. This is proprietary, secure to host API connections. And so, in the first place, the transaction should not have been discussed on WhatsApp. And so, you realize that there are a lot of internal controls issues, a lot of poor governance issues resulting into the piercing of the corporate veil. What does that mean for us? It means that if you're a young entrepreneur, again, just like the Chairman Wuntumi case that we discussed, you have to make sure that, especially if you're operating in a highly regulated environment, you have to make sure that conversations, transactions are carried out on only or through approved channels. WhatsApp is a good messaging tool, but we cannot do formal contracts, formal agreements on WhatsApp when there are dedicated, authorized API software platforms that we are supposed to have used. That's the first thing we must understand. The second thing we must understand is to ensure that there are effective and efficient internal controls. One of the key issues here will be poor internal controls. Internal controls must be in existence. Then there has to be separation of power. Separation. Decisions should not be made by just a handful of people. The question we want to ask is, the board of directors, were they aware that this is how some of the things were being done? Were they aware that the entity was having negative balance, variance? What time did the board become aware that sometimes monies end up in the private Momo account of the CEO? Did the board come to a realization of identifying the blending, the amalgamation of the business's funds and personal funds? Board must be aware of that. And so there has to be an efficient and effective board. This is where internal auditors are crucial. So did the internal auditors see this? Are they independent to be able to carry out their work very well? Did they flag it? Okay. How long has these things been happening? How about their external auditors? Did the external auditors see some of these things? What were their comments on these? Because now their licenses have been revoked. And they are now in procedures, in the process of trying to make various arrangements and pay back whatever amounts that they owe based on the SWIFT advices that have been issued. And these are the things that we must understand here. Again, this case is an ongoing case. And as of now, the summary judgment is what is being executed, but it is being appealed, but their licenses have been revoked, and they cannot no longer issue SWIFT advice, receive, or make any transfer or payment as of today in Ghana. These are the things that you must understand. And so you realize that good corporate governance is very important. The role of internal auditors and audit committee, very important. Making sure that communications are done through approved channel using official standardized regulatory approved means are all crucial. Because when it gets to court, these are the things that will come back to bite the company at the end of the day. Let me hear from you in the comment section. What do you think about the subject matter issues? And as we say always, nothing stated here is to disrespect, defame, or bring into disrepute any company or any individual. Whatever we share here are in the context of the judgment that has been issued, with comments given based on the facts that we have available. And we are not here to write off or defame anybody based on what we are doing here. It's for educational purposes, and that is why we are doing it. Thanks for watching. So if you learned something from this video, remember to like, follow, subscribe, and share the video so that others can also see this. Most importantly, let me hear from you if there are any questions you have, or if you have any topic that you would want me to cover on the next episode. Leave it in the comment section. I want to read from you. If you want to enroll as well in our courses to study under my mentorship for your ICA, ACCA, SEMA, or ICANN examination, you can head on to our website, NhyiraPremium.com, or download the Nhyira Premium mobile application on the Google Play Store or the App Store to complete your enrollment. You can also send us a message on WhatsApp or call us 050-114-9296. 050-114-9296. Complete your enrollment today to join our community. Let me hold your hand, provide you with the blueprints that you need with the team here. Let us assist you. This is our mission. This is what we do. This is what we are called for. And we have the resources, the skills, the expertise needed to help you to pass the examination. So visit our website, NhyiraPremium.com, to read more about us. Or better still, download the Nhyira Premium mobile application on the Google Play Store or the Apple App Store. You want to get personal? Hit us with a DM or send us a message on WhatsApp 050-114-9296. Thanks for watching, and I'll see you on the next one.